their significance claim states that mature-rated video games are harmful to children. This is not the case because according to recent studies by researchers, violent juvenile crime in the U.S. has been declining as violent game popularity has increased. The arrest rate for juvenile murders has fallen 71.9% between 1995 and 2008. The arrest rate for all juvenile violent crimes has declined 49.3% in this same period. In this same period, video game sales have more than quadrupled. As for the inherency claim that says there should be a law to have a rating restriction on the ESRB, and the solvency claim that involves regulating the access to mature-rated video games by fining retailers if they do not follow the policies set forth, will cause great disadvantages. On the heresy claim, according to the ESRB official website, downloadable content that will be appended to an existing previously rated project need only be submitted to ESRB for rating if its content exceeds that which is in the existing core product. Otherwise, the rating assigned to the core product is applicable to the downloadable content as well. Where, however, the downloadable content submitted to ESRB is in fact found to exceed the rating assigned to the core product, a different rating will be associated with that downloadable content. And addressing the solvency claim, according to an article written by Kelly Williams Cobb titled "Supreme Court Takes Up First Video Game Case," she says there also are numerous practical and legal problems with implementing video game bans. As argued, the case has profound implications for online gaming, which is quickly replacing physical game purchases at stores. The California law specifically targets physical video games, which means it is either ineffective for online gaming or would be expanded in the future to apply to online games. Yet, online age verification systems are highly difficult to implement and easy to subvert. Further, it would require all gamers, including adults, to verify age, another First Amendment constitutional violation. And regarding the issues about parents that my opponent brought up, according to Media Awareness Network on restricting access to these violent video games, they state that approach your local video game store and ask them to put a restriction on your account that will prevent your children from renting or buying games that are rated for older players. Most stores will honor this kind of request, even if they don't follow through. Find a more cooperative, family-friendly store. Another thing that I want to mention is by an article who was written by Henry Jenkins titled "The Video Game Revolution: 8 Myths About Video Games Debunked." Jenkins states that, meanwhile, a sizable number of parents ignore game ratings because they assume that games are for kids, 1/4 of children ages 11 to 16 identify an M-rated mature content game as among their favorites. Another thing I will say is that, according to Douglas Lowenstein, president of the Interactive Digital Software Association, video games are a constitutionally protected form of expression, and that government cannot legally enact laws regulating the sales of violent video games to minors. They have the same constitutional status as a painting, a film, or a book. So saying that it is not a form of speech is invalid. Paul M. Smith, a lawyer for the video game industry, made the following statement in regard to the sale regulation of graphic video games. He said, "Current First Amendment doctrine would not allow it, and social science studies do not suggest that a law banning violent video games would be good policy even if it passed constitutional muster." So even if it was seen as constitutional, it still may not be a good policy to pass. So why does it come down to the negative side being right? Well, if we don't restrict the access to these games to minors, it would be more efficient and less costly. more efficient because the courts would not have to deal with all the drama that this proposal is causing. It would be less costly because it wouldn't be spending money for these court cases to commence, especially when the court has said no to passing the law multiple times now due to First Amendment violations. Recalling the evidence I mentioned earlier, if the law did not pass, it would cause more disadvantages than benefits, which would in turn lead to even more inefficiencies. We would spend more money in trying to just keep something regulated that does not need any regulation at all. Why fix something that is not broken in the first place anyways? And this is what gives our proposition more validity than that on the affirmative.